and IP management for startups. Before proceeding the session, I would like to welcome our Honorable Chief Patents, Dr. Alka Das Gupta Ma'am, Chairperson BBD Education Group, Mr. Virat Sagar Das Sir, President BBD Education Group, our respected Director Sir, Professor Dr. S.S. Chauhan Sir, BBDIT. Now, I would like to welcome our respected eminent speaker, Dr. M. Selladurai Sir. Sir has done PhD from Perrier EVR College, MPhil from AVS College of Art and Science, MCom CA from AVS College of Art and Science, and BCom CA from AVS College of Art and Science. Sir has experience of 3 years and 11 months in research, 3 years, 2 months of teaching experience in AVS College of Art and Science, Padmani College of Art and Science, and St. Joseph University, Nagaland. Now, I would like to welcome our faculty coordinator, Dr. Preeti Mishra Ma'am, IIC President, Assistant Professor, Mr. Vinay Kumar Yadav Sir, Faculty Coordinator. Now, I would like to hand over the mic to our respected Dr. Preeti Mishra Ma'am to welcome our eminent speaker. Ma'am.
Thank you, Chitiz. Good morning, everyone. And I, Dr. Preeti Mishra, President, IIC BBDITM, wish you all and one present here a very good morning. I extend my gratitude to Honorable Chairperson and President BBDEG Shri Virat Sagar Das ji for providing this wonderful opportunity to organize such events. I extend my gratitude to respected Professor Director S.S. Chauhan sir. And I wish a very good morning to all the participants who have shown their interest for attending this session. And now I owe a very warm welcome to Professor M. Selladurai sir for sparing time and taking this session. And sir is having a vast knowledge in this field. Sir is the innovation ambassador. So sir has done a specialization in this field, and they are all trained from the governments in this regard. And sir is from the St. Joseph University, Nagaland. So sir, very good morning to you. And we again welcome you. And today's session is regarding the intellectual property rights, which is a very, you can say a very hot topic these days, because in this tremendously changing scenario, when the world has become so much vibrant, all the countries are working on this startups business, and every day new businesses and new things are emerging out. So naturally, this IPR topic is very much relevant for today's changing scenario, and the sir is going to take the session on the same. Intellectual property management is like, it is related to many things like patent, trademark protection, design protection, and copyrights. So now, sir, dice is all yours. Please, you can start over the session.
Yeah, thank you, ma'am. Thank you so much. Dear participants, is my voice is very clear to you for clarification purpose? Ma'am, is my voice is audible?
Yes, sir. Yes, sir. You're audible, sir.
Yeah. Thank you, sir. Thank you so much. Thank you so much. Thank you for the warm welcomes by Preeti Mishra ma'am, Avinash sir, and my sincere thanks to the whole management and the whole team of the IIC of Babu Banarasidas Gajirabad. Thank you so much. And now I'm going to start my session with my presentation. So is my screen is visible to you? Sir, anyone take the
Yes, sir. Your screen is visible, sir.
Yes, thank you so much. Watch. Stop my session. Today the topic is, already ma'am said that it's a hot topic in the present scenario, intellectual property rights, IPR, right? Either we are known or unknowing about this, right? Intellectual property is a word which is a very trendy one in this scenario, right? Already ma'am saw that uh, for creating job opportunities by the younger generation, intellectual property rights is one of the most effective way for converting these students to a IP operators, right? Those who are filing their patents, those who are getting their copyrights for their inventions as well innovation, I assure that they will reach a milestone of their life, right? Basically, we want to know about the term intellectual. There are a lot of definitions, lot of explanations by various eminent speakers and eminent personalities for that word intellectual. Right? Intellectual means is nothing but our inventions, innovative thinking. Right, that's it. Basically, we have two kinds of assets. One is tangible assets, the other one is intangible assets. Like that, I will explain you with a small example. In our life, we can classify our property, our assets, as two major categories. The one is physical property, and the second one is intellectual property. Right? Uh, all of you, can you please answer me whether my voice is clear or not?
Sir, it's clear.
Ma'am, do you hear any background voices from my side? That means playing a song like that or an announcement.
No, sir, it's fine.
Yeah, okay, thank you so much. Because in our institution, the annual sports meets are going. Last 3 days, it's going smoothly, and today is the final day. There are some celebrations doing outside. So only I'm asking that if it happens, my sincere apologies for that because I can't avoid this situation. Right? Sorry, and I'm going to continue my session. As per the discussions, we have two kinds of property. The first one is physical property, and the second one is intellectual property. Right? And the physical property means we can easily say that our own house, our own buildings, our own constructions, our own vehicles, our own transportation, our own ornaments, jewels, finger rings, chains, earrings, as well the money, right? These are called as the physical property, okay? And the intellectual property means it's our innovative thinking, right? That inventions coming from our mind, coming from our voice, coming from our thinking, it will be called as the intellectual property. For example, a book, a novel book written by a eminent author will be called as a book is called as an physical property, but the contents involved in this book will be called as the intellectual, right? Because no one can contribute or no one can steal the information inside the book, right? And the second one is music, right? All of us know music is an unique one, right? Originally composed by the composer will go the entire rights on that music. No one can include their participations in the music itself, right? And the third one is medicines. Medicines will be created by the medical companies, but the formulations for producing that medicine will be comes under a patent. For example, we already cross over a very tight lifestyle. That means that pandemic, that lockdown, the huge virus called as the corona, right? Till now, we have no curations for that corona, right? If we found any preventions or any purifications for that coronavirus, it will be comes under a patent, and if you find, it will be your life changing moment, right? And the last one will be called as the engineering purpose, right? Models, right? If for example, in that model, I want to say that we are having that EV charging stations, right? For I don't have much knowledge about that EV charging station. Okay, for example, if a EV charging station takes a half an hour for recharging a vehicle, right? But you are a engineering student background, you are inventing a new technology. You are inventing a new technology that recharges the same vehicle within 5 minutes. Within 5 minutes. I think it's not possible at this time, but it's sure that it will be happen in over the future. Right. Within 5 minutes, a whole vehicle can be charged by a EV station. Right. Otherwise, we all know that a solar, right? Solar charging. In our nation, most of the places are covered under the solar station, but I didn't think that a moving vehicle is operated by the solar vehicle. If you are inventing that, it will be called as the intellectual property, right? That means your creation, your critical thinking will be called as that intellectual. You are going to patent this idea, right? As well, the invented products also, because in our areas, the intellectual properties can have major areas like that, patents on the domain names, industrial designs. Industrial designs will be completed, right? Confidential informations, inventions, moral rights, database rights, works of authorship. That means that book, right? Service marks, logos, and trademarks. It will comes in the next line. Design rights, commercial secrets, commercial, and I will explain this all in a single slide on. With a single product, I will explain you all these things, right? This will be called as the physical property and the intellectual property, and these are the differences between the physical and intellectual property, right? And these are the informations I want to share with you. That logo, right? Logo, this will be an Apple logo, and this will be the major business holder of India, Tata, the Tata Group, and this the Apex Bank of India, State Bank of India, right? And this will be the Xiaomi, and this will be the very frequent thing we are using in our life, right? In past 5 years, we are searching every information from the Google search engine, right? But right now we are everything getting our information from the Google Play Store only, right? So I am showing this slide for patenting your logos, right? Because these logos are already operated by their owners. We cannot use these logos without their proper permission. Okay, if we are using this logos for promotional activities or for commercial purpose, they can easily file or they can shoot a case against us for
Excuse me, sir.
evaluating
Sir,
their. Yes.
sir, your slide is not moving, sir.
Oh, sorry. Just a second, sir. Just a second. I will check. So give me a second. Sir, is it visible now? Kindly give me your
Yes, sir.
confirmation.
Yes, sir.
Yeah. What the slide is visible to you, sir?
Sir, the physical property and the intellectual property.
Yeah. Okay. Right. Thank you. Thank you so much. Oh, sorry. I'm showing these slides. I already explained this concept. Sorry for that. Right. I'm not. Okay. these are the logos we discussed right now, and I move to this next slide. This will be a basic definition of that intellectual property. Intellectual property refers to creations of the mind, such as the inventions, literary and artist works, designs, symbols, names, images used in commercial purposes. Right. While we are converting our creative thinking into a commercial purpose, it will be called as the intellectual property rights. Okay. And I will show you an example also how we are going to convert our intellectual thinking to a commercial one, right? And for this, in this image, trademarks is one of our thinking, and patent is one of our novelty ideas, and for copyright also, right? And this is an image. You can look into it and get the information what they are showing, right? There is a locker. There is a lock that provides a safety for our physical property, like a motor vehicle or a bicycle, like that. Okay. Why we are protecting that? Because that vehicle is depends on us, right? It's our vehicle, so we have to protect our vehicle. For that purpose, we are using the locking purpose, right? As well, we are having all of us, right? All of you, the younger generation of India, having many critical ideas, many critical thinking, many innovative ideas upon your mind, right? Using that inventions, we can change the whole world. As well, we have to protect our innovative ideas because our society is always ready to steal the better ideas from the younger generation, right? For example, lot of commerce companies, that means multinational companies, are utilizing these innovative ideas of the student, right? Uh, all of, I think, all of you from the engineering background, do you know the hackathons, right? In that hackathons, our students are going to participate in that, and they are going to show their talents as well. If their inventions or their thinking is a novelty one, they will surely get the prizes apart from this competition, right? The MNC companies are noticing this each and every hackathons have conducted over the world, right? They are watching each and every presentations of the students, right? If the companies are find out any innovative thinking regarding their business, they are regarding their ownership, they will grab you, right? Surely they will grab you, and initially they will appoint you as an employee in their organization, and they will get the whole informations from you, right? If it happens, we cannot prevent it, right? For that prevention only, we are going to copyright our, we are going to file a patent against the theft, okay, against the misusages of our invention is called as the copyrights or patent or trademarks, like that. Okay. Why we need the intellectual property rights? Why we need the IPR? The simple answer is to exclude others to use our inventions or our copying works or from our talents or from our skills, to exclude others, right? So we are restricting others to using of our ideas, right? So we are using this IPR, and the major reason is, for the economical benefits, for the commercial benefits, for getting more money from our thinking, right? For getting more money from our thinking. This is the basic need why we are going for a IPO or a patent, right? The two things is to restrict others from using of our inventions. The second one is, and the most important one is, to get more money from our thinking only. right? We are not going for any other purpose. We are doing our thinking and we are copyrighting it and we are getting more money from our thinking itself. Okay, right. And these are the types of properties. The first one is patents, trademarks, copyrights, industrial designs, trade secrets, designs, geographical identifications, like that. Okay, and we are going to see some of this in this session. And the first one is covered by the patents. A patent is an exclusive right granted for an invention, which is a product or a process that provides in general a new way of doing something or offers a new technical solution to a problem. To get a patent, technical information about the invention must be disclosed to the public in a patent application. Right. The lifetime of a patent will be 20 years. Right. After the 20 years, it will go beyond this public and it will be converted into a public property. We cannot able to extend the duration of a patent. Okay. For patent, we should invent something new. Right. We invent something new. For example, corona, till now we didn't have any proper medicines for corona. Okay, if you are ready with a idea or a formula or a medicine for this corona, easily we can get a patent for our invention, right? Okay, otherwise, the second one is having some alternative solutions for the same problem. Having some alternative solutions for the same problem. Okay, for example, if we are using an USB drive in our laptop. Okay, there is a port called an USB port, right? But that USB port is not same as with a mobile. Okay, so we are going with a converter, right? On the go, OTG cable, right? Axe cable, like that. If we are using that same cable for connecting more devices, will be called as an finding an alternative solutions for the same problem, right? Simply, I can say that we are using a separate cable for mobile charging. We are using a separate cable for transferring data from mobile to other devices. We are using separate cables for charging our laptops. We are using separate cables for charging our power banks. Okay, right? So there are 4 devices in our hand, and we are having 4 types of cables for charging each and every product, right? So you are going to invest because already these 4 cables are in the market, okay, and all the 4 were already patented by someone else, right? Now we are going to find some solution regarding this because there is a 4 product. You are going to invent a single cable which will connect these 4, right? It will be called as an alternative solution for the existing problem, right? If you found that, you can easily find a patent for that invention. Okay, first, hold it. First, you are going to find an patent for your thinking. Okay, if you are converting the thinkings into a proper product, you can able to copyright the product. Okay, you can able to copyright that product. Okay, the single cable. Okay, right? This will be called as a patent. That patent will be having negative rights. That means right to share others on doing your invention. Right? Patents will be having more positive attitudes as well. It will have the negative attitude like negative right. Negative right means nothing but I have the right? So I am going to restrict others to use my rights, to have the capacity on my rights. Okay, this will be called as the negative rights. Okay, and for that patents, we should have some novelty, right? Novelty means some originality, right? Some uniqueness will be having in our patents, right? And the second one is inventive step. Inventive step is nothing but our originality and our critical thinking should be in a unique mode, should be in a differentiate from others. It should not be a common one. Okay. For example, in this, uh, this means that your product or process must be an inventive solution. It cannot be a solution that would be obvious to a manufacturer. take the example of a different attachment method, right? Instead of welding the tubes of a string together, they might be screwed together, right? For joining two pipes, two metal pipes, we are using welding, right? We are welding two pipes to join together. But instead of welding, we can easily screw the two pipes and we can easily join, right? But it will depends upon the situation. If we are using some wires inside the pipes, it can be screwed. But we are using waters inside the pipe, we cannot able to screw that because that water will be leaking. Okay, and this invention is not a inventive process, right? Because this is a very common way we are thinking, right? So, for example, another example, we are using a bicycle or a motorcycle or a car, okay, or a four-wheeler. There is a separate headlamp for a bike as well for a four-wheeler car, right? We are using a four-wheeler headlamp for a two-wheeler, right? For high brightness, well traveled. But it's a very common one, right? So it would not come under a pattern. If we are using an LED bulb in the headlamp, it will be called as an inventive one, right? And the final one is indus- industrial applicability, and our invention should be adopted in this ideas, right? Our invention should have the capacity of commercialization, right? Any industries or that industrial units can use our inventions or our product to a commercialization. Under these categories, a patent can be filed. And till now, there are two most valuable patents are there in our universe. That two will be called as, the first one is telephone, and the second one will be a saving razor. Right? These there are so much of patents filed in our universe, and I will show you the numbers also. Out of that patent, so many patents are most valuable, right? And I picked only two for showing you on telephone, and the second one is saving razor. Okay, that telephone was invented by Alexander Graham Bell in the year 1876. Right, without mobiles or without telephones, we cannot survive in this scenario. Right, so only I picked that as a first one. The second one is a safety razor. Right, this was invented by King Gillette. Right, we all know that Gillette. Right, and this was invented in the year 19th century, and it got their patent in the year 1904. Okay, under my vision, these are the most valuable patents in this current scenario. And all of you know that iPhone, right? And it's a product of an Apple. Okay, I think many of you hold this in your hand right now. Okay, and iPhone have a huge history, right? Okay, and I will intimate you and one thing, right? All of us having our smartphones in our hand. Smartphone is nothing but, can you, any one of you, tell me the difference between a basic phone and a smartphone? Anyone can answer me. What's the difference between a smartphone and a basic phone?
The basic phones are basically used for the purpose of calling and for the reason of
Yes,
chatting with someone. But if you talk about the smartphones, they are multitasking as well as they are so reliable for
thank you,
the any
thank
computation
you,
as
thank
well.
you, sir. Thank you so much for your prompt answer, and it will be the exact answer for the question, right? Basic phones using for making a calling purpose or for messaging purpose, right? And the smartphone will be used for a multitasking purposes only, right? And I can use it as a button phone and a touch screen phone. Okay, right? And the button phone, we already know much about that. It has very limited usage purposes, but that smartphone has unlimited versions, right? And that smartphone was invented by this company one, right? Apple. Apple was invented that smart screen technology in the mobile phone. Okay, so they have already patented their smart screen technology, right? The first one, that idea, patent, right? And they already copyrighted their formulations, and they already copyrighted this design, right? We all having our smartphone in our hand, but the mobile phones manufactured by the Apple, that means called as the iPhone, it has some unique styles in their manufacturing, in their designs, in their features, in their part itself, right? These are already trademarks, industrial designs, patents, copyrights was fully done by their company. So we cannot able to manufacture a device like that. Okay, if we make a, mobile phone like Apple, they will shoot a case against us, right? Okay, so many of the companies are there, but iPhones have their unique model. No one will copy that. Clear? Okay, and this is the image like all us know about much more about that Michael Jackson, right? He is the king of the pop. Okay, he has copyrighted their shoe. Okay, which is an anti-gravity force. Clear? And this invention was done by Jap Haston, and they invented Bluetooth, and finally they patented their idea. Okay, and this was the solar panel. This was the initial version of the solar panel, which was invented by Edward Weston in the year of 1890, right? And it also was patented by Edward Weston, right? And Srivastava Singh Bhatti. Sorry. How many of you know this word or this name or this person? Srivastava Singh Bhatti. Can anyone of you tell me that? Say yes or no. Yes, sir. I know him. No, no, no. It's a very new name to us. Kindly say something about Srivastava Singh Bhatti. Preeti Mishra ma'am told that.
He's the youngest patent holder in India.
Thank you so much. Thank you so much. Thank you so much. Right. This is the exact correct answers for this question. Srivastava Singh Bhatti is the youngest patent holder till now. Right. Till now, he is the youngest patent holder of India. Right. And I will show you the history of him. Srivastava Singh Bhatti. Right. Srivastava Singh Bhatti was an Indian student who invented a six-player variant of chess at the age of 9. Right, kindly note that. At the age of 9, he invented a thing that six players can play a chess at a time. Right, and it was invented by Srivastava Singh Bhatti with the assistance of his father. He earned a patent for his invention in the year 2012. Right. Okay. He born at 2002 at the age of 9. At the year 2012, he patented his inventive thinking. Okay. And this makes him the youngest patent holder in India. Okay. For his invention, Bhatti received the Kevin Care Ability Special Recognition Award because he is an physically challenged person. Okay. But sadly, he is no more. Right. He was suffered with Duchenne muscular dystrophy, and he was died in the year 2021 because of cardiac arrest. Okay, because of cardiac arrest, he was passed away in the year 2021. Right. So at this time, he is the youngest patent holder in India. Okay, and this is the model he invented. You can see it. Okay, with this invention, 6 players can play a chess at a time. Okay, right. These are the jurisdiction patent officers in India. 4 patent offices are running. The first one is Mumbai, the second one is Chennai, the third one is Delhi, and the fourth one is Kolkata. Right? We can easily approach any patent office throughout India. Okay, we are living in Jammu Kashmir, right? And the nearest patent office is New Delhi. But we can approach that Mumbai office or Chennai office or Kolkata office is not a problem. We can easily get patents or copyrights from any offices, right? And patents will be classified into priority date, provisional specification, and complete specification. The priority date is when we are going to file a patent, right? The initial stage will be called as the priority date, and in that there are 2 classifications. The first one is provisional specification, and the second one is complete specification, right? The single difference between these two is provisional specification is we are moving towards a success of the process, right? We are still working on that process, but till now we didn't complete the process, but a scaring purpose only, we are going to patent our thinking or our process in the initial stage, right? For example, for making a solar mobile, okay, for making a solar mobile, kindly think of that, right? For making a solar mobile, the provisional specification and complete specification is nothing but we are in a processing way. Till now, we didn't complete that process. But in the initial stage, we are going to patent that I'm preparing a mobile solar mobile, right? But it's on process. Till now, it didn't complete. But I want to patent it that idea. Okay, this is called as provisional specification, and the complete specification is once the whole process was done and the product is ready, we are going to file a patent. Okay, so these are the 2 areas, but provisional specification, we are filing our patent under provisional specification. Within a year, we have to complete our process and we have to submit that for patent. Otherwise, it will be ineligible for getting patents. And then we are going to apply for a new patent. Okay. Uh, for what purpose this can be classified into 2, provisional specification and complete specification, right? Simply I can say that I and my friend both are working together on that solar mobile. Okay, both are working together on the about that, right? He is just an assistant for me, clear? But I have no idea about that patent, but he is having much ideas about that patent. Okay, if I fail to file the patent on my mobile before completion the process, I thought that after completing my process, once the product is ready, I'm going for filing a patent. Okay, but my friend already filed a patent on my idea. Okay, on my idea, it will be called as a cheating one. Okay, but at that situation, I cannot fight with him. I cannot uh, explain the situation to the patent office because the patent was already granted to him. Okay, but the original idea was done by me, but patent was granted by him because that patent filing process was initially started by him only, not by me. Okay, for this purpose only, these 2 classifications are given here: provisional certification and complete specification. Okay, so kindly do your patent once you are ready, right? And these are the things we are not able to get patents, right? These are the patenting process. I will explain you in later. These are the common mistakes made by the inventors, right? Those who are going for patents, common men are making these mistakes, publish their invention before filing patent application, right? Before filing their patent application, don't publish in any public authorizations. Okay, don't show your ideas in any public or any societal images. Okay, if we do that, we cannot able to find that pattern. Okay, we cannot able to find the ideas for our pattern, right? The second one is use of invention in public or commercial use of invention in public or even in secrecy prior to filing patent application, right? So use of invention in public. Before filing our patent, we cannot, we can, but it's not preferable, right? Before filing a patent, for example, I already said that solar mobile. Okay, before I am going to file my patent for that solar mobile, I should not disclose this information to the public, to my friends, to my relatives, to my social media, anything. Okay, if I done, I showed this information to this public, it will not that able to file the patent. Clear. The third one is wait until the invention is fully developed for commercial working before applying for patent. Right. So these are the common mistakes made by the common people. And these are the types of patent applications. But we are from the economic, we are students. We always choose that ordinary application. Okay. And I will show you the fees applicable for that. This will be the patent application fees in the initial stages. In the earlier stage, for filing a patent, the patent application fee will be rupees 28,000 for a single patent. For a single patent, we have to pay 28,000 as a fee, as a charge, right? But the government is revising these patent application charges, and they have cut 80% of the charges, right? After the September 21st, 2021, the patent application charges was reduced to 5,600 only. Okay, 5,600 only. And that 5,600 can be split into two. For filing fee, it can be paid up to 1,600. And for requesting examination fee, it will be 4,000. Totally 5,600 we have to pay for filing a patent, right? And these are the classifications on these filing patents. And normally we are doing under this category, right? For this 4,000 and for this 1,600, 1,600. Okay, 1,600, 1,400 will be the whole charges for filing a patent, right? For getting a patent, it will take 1 year to 1.5 years, right? Minimum 6 months we have to wait for getting our patents from the government of India. Okay, so minimum 6 months to maximum 18 months. Okay, clear, right? And the number of industrial patents filing in India is each and every year it is increasing gradually. That means the patent filing process in India. In the year 2020, it was the highest number of patent filings. 56,284 patents was filed in the year 2020. Right, but it was the status of October 2021. Right, clear. In that year 2022, I'm expecting that a huge number of patents will be filed in the year 2022, right? And these are the top 10 countries we have filed patents in a large manner. In that first, China, they have filed 69,540 patents in the year 2021, right? And US will be the second one, filing a patent of 59,000, and the third one will be the Japan, right? But in the top 10, there is no India, right? That's a very sad information. So we have to know in which position we are, right? In which position we are. And the answer is India holds the 48th rank in Global Innovation Index. right? India holds 48th rank in Global Innovation Index, right? So we have to improve our patents filing process, right? Okay, then only we can lead India to the top 10 or the toppest one. Okay, right. This is PCT application top. Who are the top patent filers in India? Right. In 2020, IIT was that top each and every year. Sorry, each and every year now, because in the year 2018, TVS Motor Company was the toppest patent filer, right? But in the year 2019 and in the 2020, Indian Institute of Technology of India will be the toppest patent filers in India, right? In the year 2020, they has filed 78 patents, and the TVS Motor Companies filed 51 patents, and the Council of Scientific and Industrial Research filed 46. Right, Tata Consultancy Service, UPL Limited, Hero Motor, Tata Reddy's, IIS, Mahindra, right? Okay, and it will be called as an industrial design. An industrial design constitutes the ornamental aspect of an article. I will show you an image, right, for betterment understanding of this industrial design. Industrial design is nothing but a shape and configuration, right? This will be a bottles used in our toilets or perfumes or oils or cosmetics, everything, right? We are using this kinds of bottles, right? And these bottles can be handled by most of the companies, right? Most of the companies using these kinds of bottles for manufacturing or for marketing their products, right? If we can able to remodify these images, these shapes, we can able to find a patterns of our own originality ideas or our own designs. Okay. For example, I already said that uh, Apple phone. Apple company is already filed an industrial design for the smartphone. Okay, so no one can claim this design for their patents. Okay, clear? Because this design was already filed by someone else. Again, I told that images having so many varieties of these sizes. Okay, if we are able to modify these shapes, we can able to file a patent on this, right? As well, these scissors or cutters, right? There are so many varieties of cutters out there. If you are having that knowledge to modify this, you can have to file a patent on your own models. Okay, this will be called as an industrial design. Because you are from engineering students, you can able to produce more and more designs for the products which you are serving with very limited kinds of products. Okay, and this will be called as the patents. We can able to file a patent we are inventing. Okay, and these are the ornaments. If we are using an unique model for our ornaments, we can able to file a patent for our ornaments itself, right? As a manufacturer, not a user. Clear, right? And for this color combination, we can able to file a patent for our color combination also. And 3D designs, we can able to file a patent for our designs, right? And for this industrial design, the period of industrial design will be 10 years, and it can be extendable for further 5 more years, right? And this is the image I want to show, that in a single product you can see that 1 2 3 4 5. Okay, the first one is copyright. Copyright is for logos and that formulas, right? Script design, copyright for these logos and the designs of the bottle or the product, right? And the second one is a trademark. Trademark is nothing but that logo and that Coca-Cola brand image, right? That bottles, this all comes under that trademarks. The third one is patents. Okay, that patents is was filed by the Coca-Cola company, that everyone knows about this bottle, right? In that bottle, there is a cap. In that cap, we can find a small plastic wrapper, right? That idea was patented by this Coca-Cola company only, right? We can see a small plastic layer inside that cap. Okay, that was copyrighted by that Coca-Cola company, right? And that trade secret formula for making that Coca-Cola drink, right? That taste, that flavor, that formula will be copyrighted by that Coca-Cola, and the design, whole design was registration, that's a minute, lapsed in the 1940, right? They have already registered their design, but the design was lapsed in the year 1940, because what it means that after 1940 everyone can make this kind of design, right? Before that we cannot able to make this kind of design, but after that it will be comes in a public usage, right? Right. And for this, there's also phones which having each and every aspects of the intellectual property. This phone having patents, this phone having copyright, this phone having secret, this phone having design, this phone having trademarks, right? And I will share this PPT for with you for that understanding, right? Copyrights, copyrights is nothing but copyrights is an intellectual property that gives a owner the exclusive right to copy and distribute their creative work, usually for a limited time of period. Okay, these are some of the examples for getting a copyright. Right, artist works means their paintings or a book or a sculpture. Right, if I am a sculptor, I am designing a statue. It can be easily copyrighted by or get patented by the sculpture, right? Or a movie maker, or a song composer, or a lyricist, right? I hope that all of you saw the movie, or all of you know about that movie name called Puspa, right? In that movie, that actor, that hero, frequently saying that like this, Puspa, Pusparaj, right? If it happens, he may file a patent on that dialogue delivery. Okay, the dialogue delivery will be get patented by the hero, right? And the second one is dialogue writer, right? Because it's his thinking, the dialogue writer thinking. In that situation, that actor will file a patent for that acting, and the dialogue writer will get a patent for that dialogue. Okay, simply we can say that a song is composed by a song composing master, and the lyrics was uh, get by the lyricist, and it was compiled by the director, and there is artist, and there are cameramen. Okay, and the song was sung by the singer. If we are going for the patents, each and every aspect of this song can be patentable. Okay, for that lyrics, for that music, for the voice, for that acting, in each and every aspect we can able to patent our thing. Clear? And this will be the copyright. For the copyright, the year maximum duration of the years will be 60 years, right? The general rule is that copyright lasts for 60 years. In that case, the original literary or dramatic or a musical and artistic work, the 60-year period is counted from the year following the death of the author, right? Kindly note that point, right? Once the author of that or the owner of that innovative thinking was died, from that year onward, the 60 years will be counted, right? And I will show you with an example, right? If a book was published by me, okay, if a book was published by me in the year 2021, sorry, 2012, in the year 2012, I wrote a book, and I am the author. If I died in the year 2021, if I died in the year 2022, years will be counted. So for this whole 70 years, no one can able to copy my information. Okay, if they copy my information, I will and I will get so I will get the royalties from it.
The recording has stopped. This meeting is being recorded.
Sir, I have a question. Sir, I have a question. If we file a patent for
Yes.
some our innovation, how do we get to know that it is already been
Okay.
patented by somebody else and mine one is completely unique?
Yes. As a general public, we may not able to know how much patents are filed already, right? Because if I think it was a new idea was created by me in the North India, but it was already done in the previous year in the South India, but the patent office can able to know that our idea is a unique one or a already patented one, right? If that in that situation, for example, I already told that solar mobile, right? It was your invention, right? You think that it was invented by me only. It was not done by in the earlier period. In that situation, we are going for a patent, right? Then the patent office will get time of minimum 6 to 10 months for evaluating this. Okay, then, if our idea was patented by someone else in the earlier period, then that patent office will revise our application. They will insist us to revise your application because it was already patented by this person in that year. Okay. In that situation only, we are able to know that it was already patented by someone. Till that, we cannot able to know because in that patent office website, they will show the list of patents filed by the general public. Okay, but we cannot able to find the exact information about our thinking. Okay, I think this was the information for your question. Is it clear for you, ma'am Avi Tripathi?
Yeah, yes, sir.
Are you satisfied with my answer? Otherwise, I will explain you
Definitely,
once,
definitely,
once
sir.
again. Yeah,
Yes, sir,
okay,
I'm
okay.
satisfied.
Yeah, thank you so much.
If anybody wants to ask question, then write in the chat box or ask in person from sir.
Yes.
Yes, if anyone is having question, please ask. Also, there is a feedback form and same is the certificate form also. Please fill that form. Yes, students.
Yes, you can ask any questions to me. I will ready to answer you if you know. Otherwise, I will get the answers and I will inform you. Okay. And welcome the persons like Avi Tripathi.
Yes, anyone? They are having all clear concepts.
Okay, thank you.
So
ma'am.
you
Thank
took
so
a
much.
presentation in a very nice and organized way. For first time, I have attended the IPR session in such an organized way. And from like you
Okay,
have
ma'am. Thank
covered
you so
all
much.
the things from timeline to
Yeah.
from the what are the fees and
Okay.
who was the first person to
Yeah,
get
I
the was the
prepared the
first person who was the youngest
presentation
person to get the patent in India. And it was really very nice
okay.
session, different types of patent.
Thank you, ma'am. Thank you.
Because IPR is a very technical, I'm also having economics background. And so far I
Okay.
was knowing about the IPR, I was just thinking it is a very tough topic and it is very much technical. It is not that easy.
No,
But
ma'am.
really, it was you
At
took
this
a
situation,
session in
it
a
was
very
very
nice way and
straightforward.
very lucid way. So I think the
Thank you
students
so much.
must have learned a lot.
Thank you. Because I
Thank you,
prepared
sir.
this
Thank you so
presentation
much.
under
We
your
will
guidance.
definitely have
Yes,
more
thank you, ma'am. Thank
sessions
you so much.
from you in near future.
Sure.
And
It's my
so,
pleasure. It's my
Avi,
pleasure.
you can take the dice.
Yes, ma'am. So I guess no one is having any questions. So I'll offer you a formal thank you note. It was indeed such an insightful session. Your talks
My
definitely
I think
took us through very fundamentals to many visionary objectives. Sir taught us about intellectual property rights, which are legal rights to protect our creations and inventions. We also learned about what patents are, how the patent system works, the most valuable patents in the history and copyright trademarks as well. Thus, I would like to offer a very heartfelt gratitude to you, sir, for benefiting us with your time, knowledge, and such a descriptive reflection on the subject. I'd also like to extend my gratitude towards our esteemed faculty coordinators, student coordinators, and a patient audience for contributing towards making this session a successful one. I'd like to invite Dr. Preeti Mishra ma'am to offer a formal thank you note to our guest. Over to you, ma'am.
Thank you, sir. Thank you so much. It was, am I audible?
Yes, ma'am. Ma'am, you are
Thank
audible.
you, sir. Thank you so much. It was very nice session. And we learned a
okay.
lot.
Thank you so much,
All
ma'am.
the
Thank you so
students
much.
who have joined as their subject, some of the students who are running their startup, they have also joined.
Thank
I
you.
saw them in the list. So all of them must have learned a lot about IPR and it will really add to their knowledge and also to like if they are facing those who are working in this field some problem they must be now having their problem resolved in some or other way. And so definitely we will be having more sessions from your side because as an innovation ambassador all of you are very much trained in this field and you all know the basics of this entrepreneurship, innovation, and startups. Thank you so much,
Yes,
sir,
ma'am.
for this nice session.
Thank you so
All
much
the
for providing me the
from
opportunity, ma'am. Thank you so
IIC,
much.
from all the team of IIC, faculties and students, I give you a heartfelt thanks, sir, and
Thank you, ma'am.
thanks all the students, all the other faculty members who are in the sessions who have given shown their patience and attending this technical sessions. Thank you, everyone. Have a nice day. Stay connected. Stay protected, everyone.
Yeah. Thank you.
So, with your permission, ma'am,
And everyone,
shall we
please.
wind up the session? Shall we wind up the session, ma'am?
Yes, yes. Sir? Okay, so we are winding up the session. Thank you once again, Selladurai sir. Thank you so much.